Okay, so we have here our deputy managing partner, Mrs. Omolade Animashaun.
Thank you for having me.
We'll be talking about filing a divorce process in Nigeria.
Okay.
And I have a few questions to ask you regarding the process.
Okay.
So, starting with this, who are the parties to divorce?
Thank you very much. So basically, there are two parties to a divorce proceeding: the petitioner and the respondent. The petitioner is the person instituting the divorce proceeding, while the respondent is the person against whom the divorce is instituted. However, there could be a third party to the suit called the co-respondent. The co-respondent is the person cited to have committed adultery with the respondent. So if the petitioner used a ground called the adultery, a co-respondent will be added to the suit. But generally, there are two parties to the suit called petitioner and the respondent.
Thank you very much. Moving on to the next question. What are the grounds for divorce?
Okay. The law only provides for one ground for dissolution of marriage, which is that the marriage has broken down irretrievably. But this ground must be supported or backed up by certain facts. The petitioner must establish one or more of the facts to prove his case. So we have a lack of consummation of marriage. That's where the parties to the marriage never consummated the marriage. Then we have adultery. That's where the respondent has committed adultery in the marriage. We also have intolerable behavior. That's where the respondent has behaved in a certain way that the petitioner cannot reasonably be expected to cohabit or continue living with the respondent. We have desertion, which is the respondent has deserted the petitioner for a period of at least 1 year before filing the divorce. We have 2 years living apart. That's where parties to the marriage have lived apart for at least 2 years before filing the divorce petition, and the respondent does not object to the decree being granted. Then we have 3 years living apart. That's where parties to the marriage have lived apart for at least 3 years before filing of the petition in court. Then we have presumption of death. That's where the petitioner has not heard or seen the respondent for a period of at least 7 years. So those are the facts that would back up the sole ground for dissolution of marriage.
Okay. So, in some marriages, some couple, after 1 week, 2 weeks of marriage, the next thing they want to file for a divorce. So now my question here is, how long after a marriage can a divorce petition be filed?
Okay, so the law is explicit. For a divorce petition to be filed in court, the parties must have been married for at least 2 years. It's called the 2-year rule. But there's an exception to that rule. That's where there's an exceptional hardship. So in the case of exceptional hardship, a person married not up to 2 years can file for a divorce in court. But the leave of court must first be obtained before such divorce proceeding can be commenced. So if the marriage is not up to 2 years, the petitioner must first apply to the court for leave to file the divorce petition. But if the marriage is 2 years and above, there's no need for leave. The petition is just filed straight up.
Okay. In which court can a divorce be filed?
Okay, so a divorce proceeding can be filed in 2 courts depending on the type of marriage that was celebrated. So for statutory marriages, that's marriage celebrated at the registry, the only or the appropriate place for such dissolution of marriage is the High Court. But for customary marriages, such marriage can only be divorced at the customary court.
Finally, um, can you briefly explain divorce process?
Okay. So the divorce process is by and large going through certain procedures and steps. So the first is instituting or filing the divorce petition in court. The petitioner must file the divorce petition in court. Then there is service of the petition on the respondent. So after filing, the bailiff of the court must serve the divorce petition on the respondent. Then there could be a step or procedure called compulsory conference. So where there are children to the marriage, the parties would meet to discuss issues as relates to custody, maintenance, and welfare of the children of the marriage. Then there's the general court hearing. So this comprises of the trial, where the petitioner gives his evidence, and if there's a representation from the respondent, she equally gives her own evidence. Then we have adoption of final written address, and judgment is delivered in the case.
Thank you for joining us on this session.
Thank you
This
very
was
much.
really educative.
I
Thank you
appreciate
so
it.
much.
Thank you.